So if the government wants your property, you can go get yourself a constitutional lawyer, or you can become a community organizer. That's what our guest did. Doris Cassan, tonight on Public Exposure. I'm Stan Emmert. And Doris is someone who is an inspiration to us all because there was something that she felt strongly about and she fought. And so far, she's won. Doris, welcome to the show.
Thank you so much.
Okay, so you kind of look like someone who, you know, maybe the government could just run over. Is that what happened?
Well, I think it appeared that way. I think that they thought that we'd already had a couple of pieces of property taken from us, and we had, because they had, Sound Transit had decided to put their station on our corner, and Sound Transit had used eminent domain to take the corner of our property, and it was for public use, and of course we set back and allowed that to happen, and at the same time the city of Seatac had wanted a smaller portion of that, and so they took an entire acre. So maybe they thought we weren't wise enough that they could just take our property.
Okay, now for our audience, let's be specific here. Let's go ahead and get the picture up on the screen. You own the Park and Fly down at, let's go ahead, and this was property at
176 and International Boulevard.
And that's in Seatac.
In Seatac, right across the street from the airport.
Actually, let's go to the next shot because this is an aerial view. Boy, Google Earth is just great. It gives us an aerial view, and that's your property right there, right?
Looks like that's our property, yes.
And the city of Seatac came to you and they wanted to take it, right?
Well, they sent us a letter on August the 24th of last year saying 2009, that they were going to take it.
What do you mean they were going to take it?
Well, that they were going to use eminent domain to take the property.
And that was not okay with you?
It was not okay with me, no.
And why not?
Well, they said they were going to have a public use, and they were taking my surface parking lot and making a parking garage. And we knew with all of their consultants that they were going to give it to a bigger developer and take my property from us and give it to someone else.
So from you, a private property owner, they were going to go and take it for what they said was a public use, but then turn it over to another private developer. Did you know who that private developer was?
No, we didn't know who it was, or if they had established exactly who it would be, but they had hired a lot of consultants.
How long have you owned this property?
Approximately 42 years.
42 years?
42 years.
And how long have you operated it as a Park and Fly type of lot?
We have operated it for 42 years as a rent-a-car parking lot.
For the airport? Using
the airport is, of course, a destination for our customers.
Yeah, I take it people probably didn't come there and park to go to downtown Seattle, right?
No, they did not.
They went to come there and park and leave their cars and then go get on an airplane and go somewhere.
Yes.
Okay, now let's go to the Highline Times. The headline is Battle Over Eminent Domain, Seatac Development Intensifies. This is December the 10th, 2009. The Cassans own the Dollar Park and Fly surface parking lot at 174 International Boulevard. City condemned the property, and staffers said they wanted to build a public parking garage on the site for Seatac residents and an airport hotel guest who patronize the city center entertainment district. Next quote. Cassan said she and her husband had presented the 3 proposals to the city for mixed-use development on the site as part of a 6-year development agreement they signed with the city. Let's first go to this city center entertainment district. I've been to airports all around the country, and the entertainment that's around airports is, as we were talking before, it's not the kind you take your grandmother to.
Well, no, it isn't the type, and besides, airports should be utilized for the economically the best use for the property, and I don't believe that the type of entertainment that they were talking about was actually community entertainment. We noticed in some of our information that we received that they wanted to put in a casino across from the airport that should be used for hotels, parking lots, a business that would be associated with traveling customers.
Well, the next part of that quote, though, said that you guys had signed a development agreement with the city. What were you going to do?
Well, we were going to make a parking lot, a hotel. We had already spent, well, after the condemnation for the Sound Transit, we signed a development agreement that was until 2013, that we were going to work with the city to build, you know, because we like to be community, we like to do things together. So we were working in the city to build a parking garage with a hotel, a mixed use. We had brought them several different schemes that we thought would go there that would make economic sense. Every time they didn't like it, we would go back. We even put housing above that. You know, because one time they wanted housing.
This was a proposal.
Right, and we spent over $200,000 just on architects and development, trying to see what the city was wanted to happen at that particular place. But after we had the condemnation, we discovered in our Information Act that all this time, the city and their staff already knew that they were going to condemn the property. They'd already hired attorneys to how they could scheme some public use. So really, it was really dishonest in the way they had treated us.
Okay, so all you SOFA lawyers out there, let's just go straight to the Fifth Amendment. This is what the Fifth Amendment says. It says, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Now, the U.S. Supreme Court has interpreted that an awful lot. You're not a lawyer, are you?
No, I am not.
But you certainly had got to be learned in the law, so to speak, on this particular issue, right?
I did study quite a bit about it since, yes.
2005, there was a very big U.S. Supreme Court case. It turned out, from a lawyer standpoint, it really wasn't as big, but it's the Kelo case from New London, Connecticut. Man's house may be his castle, but... And then let's go to the quote. This was where the court held in a 5-4 decision that the general benefits a community enjoyed from economic growth qualified redevelopment plans as permissible public use under the takings clause of the Fifth Amendment. Now, what was the public use that Seatac communicated to you that they wanted to take your property for?
Well, our particular property, they said they were going to build a parking garage. And the parking...
But you already had
a surface parking,
okay.
Right. But they had gone around to different communities, and it had been advised that they could, other people had built the parking garage in order to get other developers to come in to make other businesses viable.
Parking garage and casino.
Right. To use for their guests. Now, the community, I don't believe, the City of Seatac community is not going to go to a casino.
Well, with you as a property owner, you'd entered into an agreement with them where you were going to try to develop the property. Was this because the City of Seatac is trying to beautify International Boulevard around there, trying to make it good for the residents?
No, I don't believe so. It wasn't for beautification, and it wasn't a blighted area. You know, they are. You know, the new concept is to make the area blighted so they can take it by eminent domain.
Yeah.
But this was not a blighted area. There are many surface parking lots. Well, at the time it was Mayor Shape, and Mayor Shape had said that our biggest complaint is surface parking lots. Well, at the same time, though...
Having know that area pretty well, that's not the biggest complaint, but we won't talk about that. It's the entertainment. We got to take a very short... Well, before we go to the break, we're going to do this right here. This is again from the Kelo case. It said, the Supreme Court majority opinion said, the disposition of this case, therefore, turns on the question of whether the city's development plan serves a public purpose. Without exception, our cases have defined that concept broadly, reflecting long-standing policy of deference to legislative judgments in the field. Bottom line on this is that if there's a public purpose served, then the city can condemn the property and can take the property. We're going to take a very short break.